This is the formula we've used, and experiential diversity is lacking. And I think this has a lot of implications in terms of the slowness with which the Supreme Court changes. I mean, fundamentally, they are steeped in administrative law. That tends to be the docket that's heavily selected. A lot of them are very deferential to government, both in criminal areas, but also in administrative laws areas, things like the Chevron doctrine. And I think that has a lot to do with who they are as people. And I think Garland, in many ways, is very much like Scalia, even though his ideology in the background might be different. But his approach, is not going to be radically different, even as strident as many people think Scalia was. But I do think one of the most important effects that will come from a new justice, and Steve alluded to this as well, is in the docket, what cases are chosen and decided, right? And so in political science and in media theory, there's something called the agenda setting theory, which is, what's often more important than people's ideological views is what's on the table for discussion. Well, the Supreme Court operates around the rule of 4, right? But of course, there's strategic use of the vote to issue cert. And Scalia had a really idiosyncratic set of interest areas, right? Things like the Confrontation Clause, things like the 11th Amendment, sometimes, maybe not. The Commerce Clause and other federalism issues, I absolutely agree with Steve. He never had any strong view of federalism except as an instrumental value. But his selection in certain areas is going to be different with a new justice. And we might see, for example, I don't think we'll see any Confrontation Clause cases. I think the Supreme Court may have already been done with the so-called sentencing revolution anyway. And so the types of cases that are selected could be quite different. Garland, I think will be very similar to the pool that's already selected. But if we have a President Trump, right, you could have a very different justice in terms of what the docket looks like, because that's often a really important factor. But it's sort of illustrating the idea that, from my perspective, in certain areas, it's not going to be, we haven't had a liberal majority, meaning Democratic appointees being the majority of the Supreme Court, in a really long time, right? For a while, we even had 8 Republican appointees and 1 Democratic appointee. So, I would argue that in many areas of law, we don't have a real liberal, set of justices that will vote reliably so. When I teach criminal procedure, many of you, who take the class with me will, notice that I say, and of course, Marshall and Brennan are dissenting, right? Because it's just every opinion, right? Marshall and Brennan are dissenting. And then you have the end of Douglas's term, so then you have Marshall, Brennan, and Douglas. And then later you get a little Stevens in there. But they consistently, over and over and over again, were against the government. Douglas would say, this time it's totalitarianism for real, and they just sort of had their little things that they would talk about. But these days, in lots of areas, there isn't really a strong liberal constituency. And I would say Hine versus North Carolina, which is, in my mind, of the time that these justices have been together, which hasn't been too long, in my area, since I was only approached to do this at 2:30 yesterday afternoon, I had to focus on the areas I know a little bit better. And so Hine versus North Carolina, I would say, is the most conservative opinion that's been issued in criminal procedure over the last several years. That's conservative here, mostly meaning pro-government, pro-police. And yet it was an 8-1 opinion. Justice Roberts, the chief, authored it. And Sotomayor wrote alone. And in fact, she's increasingly writing alone in these areas. Justice Breyer would often join the conservative government majority when Scalia was on the other side, right? They would swap places from time to time. Kagan has been, kind of pragmatic, hasn't really gotten a lot of published opinions in this area. And so when we talk about replacing Scalia with Garland here, it's not even clear Garland goes over to Sotomayor. It's still maybe an 8-1. In this case, if you all aren't familiar, is the case where a North Carolina police officer stopped somebody for having a broken taillight when, according to the North Carolina courts, that was technically not against the law, that you had to have 2 broken taillights before you were pulled over. And one of the remarkable things about this opinion was that Justice Roberts said not only was there no remedy in this case, but there was no rights violation for the Supreme Court to engage in a stop based on a mistaken view of what the law was. And this is a radical extension, in my mind, either of the good faith doctrine or a shrinking of the right that exist, but maybe it'll amount to little. It's hard to know. We haven't had too many cases here. But I do want to sort of contrast this with a different case, which was a little older. Back in 2005, the Supreme Court struck down the juvenile death penalty, and Justice Scalia wrote in dissent, "What a mockery today's opinion makes of Hamilton's expectation," announcing the court's conclusion that the meaning of our Constitution has changed over the past, I left it blank here, years. Not mind you that this Constitution's decision blank years ago is wrong, but the Constitution has changed. Right? Scalia was saying that the Supreme Court is not being consistent, they're overturning an opinion that was only recently decided. Well, do you know how many years it was? 15, right? 15 years had passed before the juvenile death penalty had been upheld and when it was overturned, and yet Scalia made a pretty big deal about this, that this is like a radical shift, this undermines the stability of the law. And I think what he's really reflecting here is a norm, which is actually the Supreme Court moves very slowly. It rarely overturns cases. I wish it would overturn cases more, so it would make it easier to teach criminal procedure, where they just leave all these lingering precedents around. But the idea that Citizens United will be overturned, I think is far-fetched and crazy. The idea that Heller or McDonald would be overturned is far-fetched and crazy, at least in the next 10 years, right? Any possibility of these recent high-profile cases being undermined, I think is very, very low. Now, that doesn't mean new directions can't occur in the doctrine and the precedent can be narrow, but actual overturns, I think, are unlikely on constitutional issues. But I did want to mention one area where I think we could see some deviation, and it wasn't at all Scalia's pet issue, but it was one where he had a consistent vote, and it was one that Professor McAllister did mention, which is voting rights. Shelby County was a pretty big opinion in changing the way voting administration existed because it got rid of parts of the Voting Rights Act. But one of the differences between voting rights cases and, say, your average constitutional issue is there's a lot of fact specificity to them. This is also true of certain areas of criminal procedure. And so sometimes precedents, matter very little because each case can be its own little universe. It can easily be distinguished from prior opinions. And I think it's in those fact-specific doctrines, things like what is probable cause, right? What are rights under both the Voting Rights Act and under constitutional amendments passed during the Reconstruction period. I think there, Scalia's absence might make a difference. But generally, I think that it's very easy to play Chicken Little and say, oh no, everything's going to change, it's very different. But we've had many justices come and go, and change is very, very, very slow. Some of it may be because of, as I alluded to earlier, our justices are all kind of very similar in terms of their experience. But it also just is, it's a very small C conservative body, right? It changes slowly. It doesn't go through radical transformation, despite the wishes of ideologues on all sides. So that's it for me.
Do you want to, I guess I would largely agree with Professor Young that the court tends to move slowly. But I do think Scalia's absence is going to make a difference. Will they overrule Heller? That is a big step. Because they're concerned institutionally that they don't look too political. So we just change one vote and now we get rid of an entire doctrine. On the other hand, I think there are many doctrines they will limit or go in a different direction without him present. There was a Second Amendment case just recently that they decided per curiam without him, but the majority simply reversed and remanded a lower state court that said it was not, the Second Amendment did not protect the right of an abused woman to carry a stun gun to defend herself against the ex-boyfriend. In Massachusetts, it is illegal to have stun guns unless you're a law enforcement officer. And the majority said, well, your reasoning is wrong, but maybe there is a reason you could uphold the law. And so they sent it back, which prompted Alito and Thomas to say, this is nuts. How can this law possibly be valid? Especially look at the circumstances. You're saying a poor woman can't have a taser to defend herself against, that's somehow not protected by the Second Amendment. And Scalia would have been right with those two if you were there. And so what I'm getting at is I do think the tone in certain areas is going to change without him. Certainly, you're not going to find the court expanding Second Amendment rights, expanding 11th Amendment immunity. So there will be some significant differences, and there have been two cases already this term that were argued that he voted in, but then died before they were decided, and they've been affirmed by a 4-4 equally divided court. One was a case I argued not a big deal, although it does have an issue that Professor Young mentioned, kind of Chevron deference. But this morning, they affirmed for the case about the unions and whether the public unions can collect dues from the members that may be used for political purposes, or if the people who object have to opt out, or whether they have to opt in. And the bottom line is, if the decision would have made a lot of difference to the strength of public unions, and they affirmed by an equally divided court, which is that the previous cases were not overruled, the unions were okay to keep doing what they're doing, but Scalia was the fifth vote who would have overruled what had happened before and would have gone a different direction. I think that's very possible in the Texas abortion case. I think it's very possible in the immigration case about the president's executive order on deportation. Scalia's his absence is going to make a difference in some of these cases pretty quickly. But I do agree with it's one thing if it's pending and he's suddenly absent and they can't do what they otherwise would have done. It's a different thing to say they're going to take a gun case next year and overrule Heller. I do agree they're not going to move that quickly or do that kind of thing.
Do you have other questions, or did you?
Well, I was going to mention the stun gun case as well, because it was kind of interesting that it was a per curiam opinion, and in a sense, one reading is the majority, didn't seek to undermine Heller or McDonald at all. And it is a remand, but what you think that remand meant, I mean, it's quite clear that the Massachusetts court basically was, putting their middle finger up to the Heller decision, right? Their reasoning was at odds with what Scalia said. On the other hand, there is a lingering issue after Heller, and I do think, it's probably right that Scalia would have joined the dissenters there, and he would have been upset, especially because the lower court opinion maybe should have been reviewed more. But on the other hand, Scalia in Heller planted maybe not the seeds of its destruction, but the seeds of its limits, right? And he did what it annoys me a lot about several recent high-profile opinions, where he just said, oh, but this right does not apply to felons, it does not apply here, And he also grounded the right very much in terms of home protection. And this case involved public possession. And one of the lingering questions that lower courts are going to have to confront, Scalia's absence might make a difference, is there a public Heller/McDonald right? In other words, it's one thing to outlaw possession entirely. There's another, as we are here, to have, in this state, have concealed carry permit without training, right? Which is allow virtually anyone without a certain class to carry. And had Scalia written the Heller opinion broader, I think it would have been harder for his successor to undermine it, precisely because of legitimacy concerns. But it was strange, because he couched it in such narrow language with sometimes artificial limits, he virtually ensured that his successor could make a difference here. Because I do think the court, and especially the chief, historically, has often cared a lot about the court's legacy and legitimacy. It is, of all our government branches, which poll horribly in terms of legitimacy, the Supreme Court's still the relative top, even though it's declined in recent years. And so, I think the areas where there's room to undermine Scalia's legacy, sometimes he set them up themselves, and other times it's just areas he didn't really focus on. So the difference here, as I said, often comes in what the agenda or the docket looks like. And Scalia's particular issues, I think his opinions will be respected. I'd be surprised to see many overturns of anything he's written. And of course, he was often in dissent, in which case his replacement as a liberal justice wouldn't usually matter too much.
Now let's open it up to questions.
Anybody have any questions for these speakers?